Welcome. While we wait for others to join, I do have two sections to draw your attention to, a couple housekeeping. First, in the chat, this is where you can find the slide deck. And then Q&A, that's for you to enter your questions, which we'll address at the end. Now, the Q&A, it might be hidden for you, so you might have to go into more. That's where I was able to find it. So chat is a slide deck, Q&A for you to enter your questions. Now, both the link to the slides and the recording will be emailed to everyone who registered. Plus, recordings of all of our webinars can be found on our Morris & Garrettano website in the webinar section. Let's get started. So thank you for joining us this latest installment of our HR in Half an Hour webinar series. Today's topic is leave administration. So staying compliant through common challenges at both the federal and California level. So that's a mouthful this morning. So I'm Kristen White, your HR compliance consultant here at Morris & Garrettano. Joining me is Angela Toomey, our internal HR director. She'll pop in at the end to help answer those questions. Last year in August, we also hosted a webinar on leave of absence, which provided an overview of the major federal and California leaves. This year, we're expanding on that topic by providing guidance to common scenarios. We'll start with a refresher on the main leave regulations, walk through a few scenarios, including how to handle benefits continuation, then wrap up with a refresher on the documentation and communications needed. When presented with the leave scenario, this is the framework I like to follow to determine the appropriate actions. What are your next steps? So ideally, these steps are followed prior to employee even needing a leave, but this is the same process even if the leave has already started. So start with going through the first two steps to determine if the leave is considered protected. So which leave laws you need to follow, and is the employee even eligible? If not protected by leave regulations, then it's more based on your specific setup, such as what do you have documented in your policies? What have you granted for other employees? How long do your benefit plans allow you to continue offering coverage? Then lastly, for all situations, evaluate what has been done already, such as any documentation or communications. Now, most of these steps are based on your company, not the employee, which means these steps can and should be done ahead of time. So do the research to educate yourself on the specifics for your company. Then when an employee does need a leave, you'll only need to evaluate their situation. To help us determine if the leave is protected, we're starting with a refresher from last year. These next few slides have a lot of information, I'm including for you to be able to refer back to. So don't feel like you need to memorize all the details now. It's more about awareness and having the resources when you need them. As you can see in the top of the table labeled protected leave, there are multiple types of leave. These are only the three main types under federal and California regulations. Separately, those bottom two rows, there's some states like California offer partial wage replacement. For example, an employee says they're taking paid family leave and they tell you they don't need CFRA. That's where you need to educate them that paid family leave is only a wage replacement. PFL does not by itself provide protected time off. So you'd inform the employee of their rights under FMLA and CFRA, then designate that time appropriately. The term protected leave is used. So what do leave regulations actually protect? First priority is protecting their job, just as if they were still working. Next is protecting health benefits, which I'll cover more in a few slides. The first step in our framework is to determine what leave regulations your company is covered under. That's mostly based on your employee count. So in California, you only need 5 employees to fall under CFRA and PDL. However, if you have 50 employees, you'll also need to comply with federal FMLA, which mostly just means more paperwork. Second step in our framework, what is the employee eligible for, which has a couple layers. So first, check their employment situation under each leave type. So that's our bottom row here. You can see in the slide, pregnancy leave is available right away, while FMLA and CFRA have more requirements. The other layer to determine the employee's eligibility is based on the reason they need time off. So you can refer back to the chart here to see the qualifying reasons and qualifying family members. An important note, if a qualifying reason falls under two leave types, they run concurrently, meaning both clocks run at the same time. The most common question on leaves is around benefits continuation. While on protected leave, the offer of health benefits needs to continue. The company continues their portion and the employee is still responsible for their portion, the same amount as if they were actively working. You have options on how to collect those premiums, such as a monthly personal check or process through payroll after they return. That's something you would arrange up front, and you want to consistently offer the same option to other employees. I mentioned health benefits. So note that these leave regulations do not address non-health benefits. However, companies often choose to continue them. It's advised to confirm with your insurance carrier on what they will allow. So if an unprotected leave is granted, which we'll talk more about towards the end, that's where you check those second set of items in our framework. Is the employee in an ACA full-time stability period? This is only for ACA applicable large employers using the optional look-back method. If you're not familiar with those ACA terms, then this step probably doesn't apply to your company. Most companies use the default monthly method to measure full-time status. Next, what do your carriers and plans allow? Such as medical carriers often offer flexibility for employers, but that needs to be established up front in your carrier agreement. Lastly, what do you have documented in your handbook leave policy, and do you follow it? As with everything HR, we need to be consistent for employees in similar situations. So that's our refresher section. Next, we'll jump into a few scenarios. Protected leave needs to be designated. That's just the formal process of documenting the leave that it qualifies under specific protections, like FMLA, CFRA, and notifying the employee that the time off will count against their leave allotment. So that's a lot, but to help, we have templates that you can use to designate all of these and communicate with the employee. So we'll provide those direct links. In this scenario, they confirm the company is covered under both FMLA and CFRA, and the employee is eligible. The employee was granted leave for their own medical condition and benefits continued. That's great. However, the company missed the documentation and communications required. Now that time has passed, the company naturally asks, when can they end benefits? Since the company missed the step of designating leave, the guidance is to do that now to restart that clock. If you don't, the risk is that the employee can later claim the company failed to provide FMLA and CFRA. Our guidance is to always designate prospectively. However, there is an argument that the employee did receive the benefit of protected leave, but it just wasn't documented timely. However, if you are considering backdating, we recommend discussing those risks with an employment attorney. Takeaway here, don't wait until you're into the leave to check on benefits. Evaluate all that up front, then document and communicate. Neither you nor the employee want surprises during the leave. This slide is a twofer because it's the same answer. So what if the employee doesn't specifically ask for a leave? Or what if they do take time off, but deny the FMLA designation, or they simply don't return the paperwork? So in this scenario, you became aware the employee may need time off. You confirm the employee is eligible under FMLA and CFRA, and company is eligible, and the employee is eligible for the leave. Next step is to inform the employee of their rights. Then, if the employee does take a leave, it's the company's responsibility to designate that time appropriately. So key point here is that protected leave is an entitlement from the government. It's your responsibility to inform employee of those rights and then designate the time. The employee is not required to ask for that protection, nor to approve the designation. If the time is not designated, then the employee still has those 12 weeks available if another qualifying situation arises. The same guidance for employee out due to workers' comp absence. You would still designate up to 12 weeks as FMLA CFRA. Number 4, one of the most common leave reasons is pregnancy. In California, there are 2 separate leaves and they do not run concurrently. So first, pregnancy disability leave, driven by the doctor's note, can begin before birth and run up to 4 months total. Second, CFRA for bonding, up to 12 weeks. So it picks up after PDL and can be used anytime within 1 year of the child's birth. So that means the employee can be on protected leave for up to 7 months total. Here, the company is covered under California's PDL and CFRA, but they have fewer than 50 employees. They're not covered under federal FMLA. If they were, then FMLA would run concurrently with PDL and CFRA. So not necessarily more time off, but more paperwork. So this employee is eligible for PDL, but not yet eligible for CFRA. So PDL applies from day 1. However, CFRA requires a year of employment plus 1,250 hours worked in the prior 12 months. And we do have that on that previous slide. So action items here, start with PDL. Then at their 1 year of employment, they reevaluate CFRA eligibility. And once an employee does meet CFRA eligibility, they choose when to take that bonding leave, anytime within that first year of birth. It doesn't necessarily need to be right after the PDL. Our last scenario. Here, every step was handled correctly. The employee was notified of their rights and the leave was properly designated. Now they're nearing the end of their 12 weeks and they tell you they're still not able to return. So what happens when the employee needs more time, or when they haven't been employed a year and aren't eligible for FMLA or CFRA in the first place? That's where it gets less straightforward. Okay, if the employee is disabled, which is based on the doctor's note, or you can use the medical certification form, 2 additional laws come into play. And most of your companies fall under both. So you have federal ADA and California's Fair Employment and Housing Act. Under both laws, you're required to engage in the interactive process. So that involves communicating with the employee, understanding their limitations and accommodation needs, exploring possible solutions, and documenting those discussions. Once you understand the request, weigh a few things, such as how have you handled similar requests, since each one can set a precedent. And the financial side, granting time off carries no direct cost, though you may need to bring in a temp, but the cost and time to replace that employee is often a bigger hardship. If you conclude a request would create an undue hardship, consult an employment attorney before you act, especially if you're considering denying the leave and terminating instead. Every case should be evaluated uniquely. Most common outcome is to allow leave as an accommodation, at least for a short period. The next question is benefits. That comes down to what your plans and carriers allow, what your internal policy says, and how you've handled similar situations. The typical outcome is continuing healthcare coverage for a month or so, then offering COBRA. I've mentioned a few times that you need to inform the employee of their rights, designate the leave, and communicate that designation back to them. So how do you do that? Listed here are 5 types you'll need, which fall into 2 categories, 3 categories actually. The first 2, these are for the rights. So they're published on government sites. You simply download them and provide to the employee based on the reason for leave. Like if it's FMLA, is it for themselves, is it for a family member, is it PDL? And that second one, so the EDD partial wage replacement notice, if they're out for their own health condition, they may be eligible for STI unless they're already being paid under workers' comp. If they're out to care for a family member, to bond with a new child, they may be eligible for paid family leave. Those next 2, number 3 and 4, the medical certifications and the designation notice, they need to be filled in. So both Mineral and the government sites have templates available for download. Federal FMLA has a specific designation form for you to use. However, California does not. So Mineral created one to fill in that gap. And lastly, Mineral offers optional template letters to help you communicate with employees throughout the leave. What resources are available? A great resource we offer free to all clients is the Mineral HR platform. It's It's a one-stop shop, especially for leaves. They have a vast library of information, plus forms and templates they developed. Plus, they have direct links to government sites. Mineral also staffs a hotline with HR experts. You can call them or submit your questions in their portal. Here we also have links to government sites. Our third resource in this slide is our UBA webinar series. So as an M&G client, each month you should receive an invitation to register for a UBA webinar that's hosted by an employment attorney. Most sessions focus on administering benefits, but July's session took a deeper dive into FMLA. And we'll share that link in the follow-up email to everyone who registered for today's session. Lastly, we have information on the webinars page of our Morris and Garrattano website. You can access recordings of our webinars, including leave of absence webinar I hosted last August that covered more details on the fundamentals. By next week, we'll post the recording and the slide deck for today's webinar, plus an FAQ and links to external resources with direct links to the forums that I mentioned. We also have a weekly updates newsletter that includes multiple topics from Morris and Garrattano, including HR and compliance updates. If you're not currently receiving our newsletter, you can sign up on our website or use that link in the slide. To summarize the framework, here are the high-level questions to ask yourself. What leave protections apply? What documentation is required? What do our benefit plans and company policies allow? What has been done in similar situations at your company? Do yourself a favor, do these steps up front, evaluate, communicate, document, ideally before leave even starts to set yourself up for success. Thank you again for attending today's webinar and to those watching the replay. This is the end of our content, but you're certainly welcome to stay for the Q&A. Remember, if you have any questions, put in that Q&A section. Angela Toomey, our internal HR director, will join us to help answer your questions. And Sophia from our communications team is going to help out by asking the questions. So Sophia, take it away. Do we get any questions?
So for now, we have one question, and it's on protected leave. Is there a resource that explains what is protected leave and what is not? Does a personal leave qualify as protected?
Thank you, Sophia. Good morning, everyone. So that's a great question. And I would like to echo what Kristen said, that Mineral is an excellent source for or resource for finding these protected leaves. And it is sort of a blanket question, and I wish that there was a list of all the protected leaves that you could just find in one handy cheat sheet. And I think the closest that you're going to come to that would be if you happen to use Mineral for your handbook, then all of those protected leaves would be in a list in your handbook. But if you pulled those in, because many of these protected leaves are going to fall under the umbrella of different laws. For example, if you were to grant leave as an accommodation that to a disability, well, that's going to fall under ADA. And there's also the ones that Kristen talked about, the most common ones. But the last time I checked, there were about 17 or 18 different types of protected leaves, and some are less common that we didn't talk about today. For example, like organ donor leave. And so these are the ones that you don't hear about every day, but they're out there. And so I would say that if you really wanted to have a comprehensive list, and I know we sound like a commercial for Mineral, but it is free, and if you're a client, and so it is worth the time to go in and really say, okay, if I were to just pull all the leave recommended policies from Mineral, you would get all of those things, with the exception of leave as an accommodation under ADA, in which that is protected. And then your last tail of that question, is personal leave a protected leave? And by itself, no, personal leave is not protected because that is just you and your policy. You're not even required to offer that by law, and it's not protected by anything. It's just when someone needs time off for a personal reason. Having said that, if you're granting leave as an accommodation, you might classify it that way, but it's still protected. So you might classify it as a personal leave because you don't have any other way in your system to classify it when they're not at work. But what protects it is ADA or California's version of that Fair Employment and Housing Act. So there is not the best place to find all these goodies would be in Mineral or in your handbook, or if you're not sure where to start looking, I would say that looking to you can call us and we'll list them out for you. We could certainly give you a good running start on what those 17 or 18 types of leave are.
Okay, thank you. And a little side note, if you want to request access to Mineral, I put the link in the chat.
Okay.
Okay. So next question, what's best practice when it comes to leave documentation and designating leaves? Should it be fully integrated with your payroll system?
Okay, that's another great question. So the first best practice when designating leave, I would say, is consistency. And I highly recommend that you use these bundled forms. You can get them from Mineral, you can get them from Cal Chamber, you can make them yourself. But the critical thing is to use these bundled forms. When I say bundled, I mean pre-made from Mineral or Cal Chamber, a source that already has all these goodies in it, because then you know it's going to already talk about all the things like benefits ending or how you're going to pay your fair share of the premiums. And it's already going to have your rights blended in some of them. So then you know you're hitting all the bases. So one is to use blended forms and designating the leaves. And then you know, okay, I started that clock ticking. And whether or not it needs to be integrated into your HRIS, I think that really depends on the sophistication level of your payroll system. If you're using QuickBooks, then I don't know that there is a designated area for that. If you use Paycom or Paylocity, they may have different modules that may be better equipped for that. And so I think it's really what works best for you and your staff, because a lot of it is going to come down to calculating when that employee's 12 weeks has stopped and started. And so that's the other thing, is that it's really important to know your payroll system is not going to calculate for you how you measure that 12-month period. So you have to know that. Your handbook has to know that. And so your HRIS system isn't necessarily going to know that unless you've programmed it in there. So those are the things that really make it important. So I think the best practice is, number one, consistency. Do it the same time every time. Have a kit, have a toolkit, so that there's a toolkit for pregnancy leave. There's a toolkit for your own serious medical condition. There's a toolkit for helping somebody else who has a serious medical condition. And if you have those, I think the consistent application and documentation is important. And yeah, I do think turning it on and off with your payroll system at the same time you're sending the letter is important. That's how we do it here. When our HR person is sending that letter designating the leave, she's also placing them on leave status in the payroll system, and vice versa. When she's sending that letter saying, hey, welcome back, and you're checking to make sure that they're safe to be at work, she's also placing them on an active status. So I do believe those things go hand in hand, and they should, the payroll system, the HRIS system should match exactly what those dates say in your letters and your designation.
Okay, thank you, Angela. Next question. If several companies have common ownership and they're all located in the same town, do you have to include all companies to come up with the number of employees to determine which laws apply?
When it comes to deciding if you fall under FMLA or CFRA, then if they're all in the same town, assuming that town is within a 50-mile radius, then yes, I would count all those people towards that 50. Did I answer that question correctly? Was that the question?
Yes,
Okay.
that seemed to answer it correctly.
Okay.
And then what if an employee does not supply paperwork once they have been placed on leave?
Well, that's a great question. So typically, when you send that initial rights and responsibilities, it's going to tell them how long they have to furnish you with some type of medical substantiation. It's going to say, you've got 10 days to give us some medical substantiation. And I think for the most part, that would hold true. But I also think that you've got to be a reasonable, examiner at that point, and you've got to ask yourself, okay, well, what are the circumstances? Is the employee in the hospital? And are they able to provide you with a note? Is there any extenuating circumstance why they can't provide you with a medical certification? And then the other thing would be is that it doesn't have to be that exact form that says medical certification. It could be if they provided you with a note, the doctor's chicken scratch that said something that maybe was not super complete, but it was something that the doctor gave you, and you can certainly ask for more clarification if it's needed. You can have the employee provide additional information if it's necessary, but I would use caution before jumping to the conclusion that there wasn't a medical thing. I would certainly go out of my way to reach out to the employee and via multiple channels to get that substantiation before going that route of assuming they had abandoned. But sometimes that does happen where they simply will go away and not substantiate, and you hopefully have it well spelled out in your policy what that looks like, that says, hey, if and also in the letters that you sent them with their rights and responsibilities, saying that if you fail to provide substantiation for your leave or continued need for leave, that we're going to assume that you don't work here anymore. And so that's going to be spelled out in your policy. It's going to be spelled out in the rights and responsibilities and the letters you've sent. And you've made every good faith effort to contact that employee, and you're just not hearing anything, or they can't substantiate the need for time off, then eventually it does become unprotected if they can't substantiate it. And then you would be in a situation where you would treat it as any other unplanned absence. Depending on the circumstance, you may want to step through it with your attorney if there's any question as to whether or not there's a reason why they couldn't provide that medical note. But at some point, yes, it would become an unprotected absence.
Okay. This is a question on FMLA. If an employee has exhausted FMLA and CFRA and is still not ready to return to work, can we offer them an extension under ADA but not job protected, allowing them to remain active but with benefits, but not holding their position?
Okay, that was a lot of, okay, I'm going to answer the first part, which is you can and should begin the interactive process. And sometimes leave is the accommodation and sometimes it's not. The accommodation would just be based off whatever that employee's restrictions are. So if they're restricted from working and leave is what's necessary, then that might be the remedy you apply. And if they've exhausted their FMLA, then you may want to consider placing them on COBRA. It really depends on what your policy says and what your business practice is. So if you always offer continuation of benefits forever and ever, or for 6 months, or whatever your policy says, then you should do that. However, if you don't offer continuation of benefits beyond that protection time when you're required to, then you may want to consider COBRA, because whatever you do, you're establishing a precedent for what other employees would expect if they were to also be on an extended medical leave. So you do want to be careful with that continuation of benefits. But yes, you can always offer the job reinstatement, but you've got to be careful because the reinstatement is different under ADA than it is under FMLA. If you're under FMLA or CFRA, then they would be reinstated to their same job or equivalent. So same driving distance, same status, same pay, same authority, same similar work type thing. Versus ADA, it's a little bit different, and you still want to work towards that, but it's not the requirements to return are different. And so you're going to be looking at a different set of criteria when it comes to returning to work than you would under FMLA. So I wouldn't say that those two are equal or identical. And the ADA is going to be based always off whatever that most current restriction is. And that could evolve over time based off the person's disability.
Okay, thank you, Angela. So we are at 10:30. We could stay on a little longer and answer the last two questions, if that's good with you guys.
Okay.
So can you have different leave rules for different states, a multi-state employer, for example?
You could. I think that for FMLA, since that is federal, if you are subject to FMLA, you just want to have the one FMLA standards. However, if you have some of your employees in California, you're going to, of course, want to have your California things that apply to them. And then for those that are not in California, you're going to want to have any unique state laws that would apply for those states.
Thank you. And if we have fewer than 5 employees, does that mean no leave rules apply?
I would not say that, I could not say that's a true statement, because if you have no fewer than 5, I still think that under FEHA, I think that you still would be obligated to do some accommodations for a disabled person. I think that you need to consider some of those things. And even with pregnancy, I think it's a stretch. I would consult with an attorney before denying a pregnant person time off, or any disabled person. I think you're just walking through dangerous waters to flat out deny people any time off for a disability or pregnancy related condition or having a baby. I would probably consult an attorney before saying no. That would just be my recommendation.
Thank you. And how about baby bonding for the father of a newborn? Is that included, and how does it get handled?
So fathers are also entitled to CFRA, and they also get 12 weeks of baby bonding, just the same as the mother. And that is for up to 1 year after the birth of the baby. And depending on how you do calculate your 12 months, but if they've had any other leaves for any other reason, that would play in. But yeah, they also get the same baby bonding.
Okay, and last question, which is a follow-up question about the ADA extension. They're asking for clarification if they are not required to hold their position if they are on ADA extension.
When you say ADA extension, you're not necessarily required to reinstate them to their same position. That guaranteed job reinstatement only applies to the FMLA CFRA guaranteed job reinstatement. With ADA, however, you are saying that, hey, if you're saying, hey, we're going to just allow you this leave for 1 more month or whatever you say, 2 weeks, and you think you're going to get better, I do think that you're saying out of good faith that you're going to return them to their position, that you should. It just depends on how long it is, and it depends on what the restrictions are. Again, with ADA, you're looking at what are the restrictions. So if the restriction changes as a result of the disability, then you have to look at, can they perform the essential functions? Because with ADA, it's a whole different dynamic. You're saying, what can we do to enable you to perform the essential functions of this role? So depending on what those restrictions are, leave may or may not enable them to perform the essential functions of that role anymore. So it's going to be unique to that restriction and that essential function of that job. So it's a different analysis that you're going through. It's not the same. The interactive process is not the same or black and white, like, yes, you get reinstated to this job or no, you don't.
Okay, thank you, Angela. That was all the questions that we had today. And I'll hand it back over to you, Kristen.
Great. Thanks, Sophia and Angela. That was great. As a reminder, we'll send you an email with the link to this recording and the slide deck. Give us a few days on that. Registration for our upcoming HR in half an hour webinars is available on our website. So thank you again and have a great day.